The Senate Judiciary Committee, they kicked off their hearings for the Supreme Court nominee Brett Kavanaugh today, and they got off to a rough start. Just take a listen.
Mr. Chairman, I'd like to be recognized for a question before we proceed.
Regular order, Chairman.
Mr. Chairman, I'd like to be recognized to ask a question before we proceed. The committee received just last night, less than 15 hours ago, 42,000 pages of documents that we have not had an opportunity to review or read or analyze.
You're out of order. I'll proceed.
We cannot possibly move forward, Mr. Chairman.
I extend a very warm welcome to Judge Kavanaugh. We have not been given an opportunity
to have a meaningful
his wife,
hearing
Ashley,
on this nominee.
Their two daughters.
Mr. Chairman, I agree with my colleague Senator Harris. Mr. Chairman, we received 42,000 documents that we haven't been able to review last night, and we believe this hearing should be postponed.
I know this is an exciting day for all of you here,
Mr. Chairman,
and you're rightly proud.
Mr. Chairman, if we cannot be recognized, I move to adjourn.
The American people.
Mr. Chairman, I move to adjourn.
Directly from Judge Kavanaugh later this afternoon.
Mr. Chairman, I move to adjourn. Mr. Chairman, we have been denied real access to the documents we need to advise.
Mr. Chairman, regular order is called for.
Which turns this hearing into a charade and a mockery of our norms.
So that was an interesting start. Then you had New Jersey Democrat Cory Booker, who had it out with the chairman, Chuck Grassley, who you just saw.
This committee is a violation of the values that we as a committee have striven for, transparency. We are rushing through this process in a way that is unnecessary. And I appeal for the motion to at least be voted on.
Mr. Chairman.
At least let's have a vote, because when we wrote you a letter on August 24th asking to have a meeting on this issue, you denied us even the right to meet. So here we are having a meeting. Let's at least debate this issue. Let's at least call this for a vote. I appeal to your sense of fairness and decency, your commitments that you've made to transparency. This violates what you have even said and called for, sir. You've called for documents, you yourself, limited documents. We thought there should be more. We have not received the documents that you have even called for. So, sir, based upon your own principles, your own values, I call for at least to have a debate or a vote on these issues and not for us to rush through this process.
Senator Booker, I think that I respect very much a lot of things you do, but you spoke about my decency and you spoke about my decency and integrity, and I think you are taking advantage of my decency and integrity.
So with that, the ranking Democrat, Senator Dianne Feinstein, tried to put in perspective the chasm between what at least the Democrats on the committee are looking for versus what they've been able to see to this point.
We are also experiencing the vetting process that has cast aside tradition in favor of speed. When Justice Scalia died, Republicans refused to even a meeting in their office with President Obama's nominee, and held the seat open for 1 year. Now, with a Republican in the White House, they've changed their position. The majority rushed into this hearing and is refusing to even look at the nominee's full record. In fact, 93% of the records from Kavanaugh's tenure in the White House as counsel and staff secretary have not been provided to the Senate.
Then, about 7 hours into the hearing, we heard from the nominee himself, Judge Brett Kavanaugh.
Mr. Chairman, Senator Feinstein, members of the committee, I look forward to the rest of the hearing and to answering your questions. I am an optimist. I live on the sunrise side of the mountain, not the sunset side of the mountain. I see the day that is coming, not the day that is gone. I am optimistic about the future of America. I am optimistic about the future of our independent judiciary. I revere the Constitution. If confirmed to the Supreme Court, I will keep an open mind in every case. I will do equal right to the poor and to the rich. I will always strive to preserve the Constitution of the United States and the American rule of law.
Okay, and again, tomorrow morning, the hearings begin in earnest with Q&A with the nominee. All right, joining us now for more, constitutional law professor Garrett Epps. He teaches University of Baltimore. He's also contributing editor for The Atlantic. Well, first off, just in terms of the fights today that we've seen, which do you think is closer to the truth? That, hey, there's 440,000 pages provided, unprecedented amount of data versus, less than 10% of his records from his years both at the Bush White House and more, plus you got it in the 11th hour or in the 23rd hour if you want. We haven't had any real time to get through this. This absence of transparency is almost unprecedented. Which is closer to reality?
I think that we shouldn't, look at the number of documents. That's a kind of silly metric. The fact of the matter is this man's had a very long career. He's generated a lot of documents. The committee members have every right under committee precedent to examine those documents. And the extent to which the administration and the Republican leadership of the committee have stalled that and pushed back against it is quite extraordinary. There hasn't been anything like it in the history of judicial confirmations that I'm aware of. And in addition, the issue is the kind of assertion of executive privilege without actually invoking it. We have private actors, that is lawyers for a former president, saying we're going to withhold access to a huge number of documents on the grounds that maybe someday the president might want to invoke executive privilege. That goes against the historic practice of legislative committees, which is unless you invoke the privilege and justify it, we are entitled to see public records. Now, there's been a certain claim that Judge Kavanaugh's record as cabinet staff secretary shouldn't be available because he was doing such sensitive work. It occurred to me watching about halfway through this that if you choose to nominate a candidate for a very important office whose record is such that you can't turn over the record, then maybe you've nominated the wrong person. It would be if President Trump were to nominate the head of the CIA to be on the Supreme Court and then say we can't turn over any records because the CIA is secret. I think the answer to that is, well, find another nominee. Find a nominee that can be part of the process.
All these papers that they're apparently concerned with or whatever, at some point will see the light of day even after confirmation, and then the question obviously will reemerge, albeit he'll have a lifetime appointment at that point. So obviously there's a host of other positions he's either taken that we do know about that raise questions. And let's start first with his re-examination in terms of where presidential power starts and ends or executive privilege. Certainly, he seems to have done a 180 since he was with Kenneth Starr during the Clinton years. Are you clear at all as to where he thinks a president should or shouldn't be exempt in terms of possible criminal exposure or even civil exposure as a sitting president?
I think it's pretty clear to me that he favors broad presidential immunity from any kind of investigation, much less prosecution, while he is president. And his supporters have said, well, he never said that. He said Congress should do it. But I think the fact of the matter is that if the case were to come to the court in its present posture, it's very hard for me to believe he would not basically just say the president's immune, the president doesn't have to turn over documents, the president doesn't have to answer to a subpoena, and who knows what else. Because we have a president now who has basically asserted that he is above the law. And Judge Kavanaugh was a very important figure in the last administration that took something like that position, and that is the George W. Bush administration, which asserted executive power far more broadly than any previous administration. So I think, the red flag is flying there.
We find out as early as tomorrow, but he's going to get the question as to whether or not he would recuse himself if, in fact, questions about President Trump's presidency came before the court. Obviously, everyone's done artful dodges on questions of these kinds, but A, is there precedent, Garrett, for it? And moreover, when he gets the question, can you really avoid answering one way or the other as to whether or not you should or should not recuse yourself if you take such a pointed position on something that could potentially decide a presidency?
Yes, I think you will see him refuse to answer that question. He will say, until I see the actual facts of the case, I can't decide whether recusal in any case would be proper. And there's some truth to that. You couldn't possibly expect any nominee to say, I'll recuse myself from any case in which the administration is a party. That's ridiculous.
On the subject of Roe v. Wade, Kavanaugh has said he believes it's settled law. You wrote a piece in The Atlantic where you said that's an unsettling answer. Why?
Well, I think, first of all, the term settled law has got no technical meaning in constitutional law. I've tried very hard to find it. And basically, the best definition I've come up with came from Justice Stevens, who basically said settled law is law the court has not decided to overturn yet. I mean, Judge Kavanaugh has only really got one serious opinion on the issue of reproductive choice, a case called Garza versus Hargan, in which he refuses to acknowledge that the constitutional right to choose exists. He keeps saying, quote, existing Supreme Court precedent or current Supreme Court precedent would indicate that the individual in question has a right to choose abortion, but we don't need to reach that case because the government can find other ways to block her from having an abortion. It's an extraordinary performance because the individual involved had fulfilled all the requirements of Texas state law. And just think for a minute, it's not easy for a minor to get an abortion in Texas. No. She has to go in front of an elected Texas judge and convince that judge that she is mature enough to make the decision. She had done that. But Judge Kavanaugh then goes on to say, yes, but maybe we could get her to rethink it. The government really doesn't want her to have an abortion. The government doesn't like abortions. That's a pretty radical position under existing precedent. The court has said the government may indicate to people that it prefers childbirth to abortion. But I don't know of any case where it basically says the government has an independent interest in blocking you from having an abortion because the government, disapproves of that. And I frankly think anybody who supports reproductive rights, as I do, reading that opinion ought to get a cold chill up their back. It's pretty clear what's coming.
We can't exaggerate, can we, Garrett, in terms of, if confirmed, how much of a significant impact, generational potentially, on issues, whether it be affirmative action, environmental protection, I can go, and you can go farther than I, and a host of other issues that this one swing vote could have.
Absolutely. I think that not since at least the mid-'80s, and probably before that, has there been the potential for one appointment to so upend settled understandings of what the Constitution means and establish precedent in front of the court. Both Judge Kavanaugh and now Justice Gorsuch have indicated, a great deal of skepticism about the idea that the court should follow its own precedent. Everything is going to be on the table, and it's really going to depend to a significant amount on this one individual.
Will be an interesting week ahead of us here, at least. Garrett Epps, thank you so much for the time. I really appreciate it.
I enjoyed it.
All right, when we come back, some remarkable eulogies at John McCain's funeral Saturday. Two former presidents speaking about the late senator, but they also spoke about someone who was not there. And of course, referring to President Trump, and they didn't even have to mention his name to make their point.